Hello everyone, this is Olga Media. As you know, we support technology, culture, and people. And Bob Zeidman with us, with interesting background and expertise, engineer. Maybe you just tell us yourself.
Sure. Thanks, Olga. Thanks for having me. So what I was going to talk about is my work on intellectual property litigation and my software company that produces tools to help with intellectual property litigation. They're software forensics tools that are used to analyze software to find copying. If one company accuses another company of copying its software, maybe an engineer has left, taken software with him or her, used it in another product. That's the kind of thing that our tools can find.
Now, when we're talking about the company, you founded your own company?
Yes. So it started out as Zeidman Consulting, which has started out, it was just me doing consulting and consulting for litigation. Well, even before that, I was actually designing hardware and software for companies.
Okay.
And eventually I started doing more and more litigation where I would take things apart, hardware and software, and determine, did someone copy someone's hardware? Did someone infringe on someone's patent? And then I developed some tools that I call CodeSuite that will automatically compare software and find where it's correlated. And there's a whole process I've developed for looking at the correlation, using the tool to determine if code looks the same or sections look the same. Is it because they're copied, or is it for some other reason they're both third-party code? And so the consulting business expanded at the same time that the software business expanded, as these tools became more popular for use in various software litigations.
Great. So you're not consultant. I mean, you maybe are, you founder, but also perhaps bigger name expert witness?
Yes. Well, I say that I'm an expert witness. Most of the time, these days, I am the listed expert witness in court. A company hires me to testify. And these days, I usually have teams of engineers that use these tools that I've developed and use the processes that I've developed and just use various techniques that I've trained them in to do the analysis. And I oversee that, and then I testify in court. But the fact is, most cases, I never get to testify. Usually by the time the analysis is done and I'll write up a report, and the other side has their expert write up a report, and usually it's pretty clear at that point who's right and who's wrong, and then the parties settle. But when it does go to court, I testify.
Now, you are very shy to tell about your own patents. Can you share with our community what those patents were all about?
Sure. Well, one of the reasons I got interested in patents was that some years ago in the 1990s, I started a company, and I thought, well, I'll patent this technology. And then I went to a lecture at the Stanford Business School by some professor, well-known professor, who gave a lecture and said that patents aren't valuable anymore, that technology moves too quickly. So I decided, well, why spend my money on a patent when it's not valuable? So several things happened after that. One is I abandoned my patent. Somebody else got a patent on the technology. It's remote backup, places that back up remotely over the internet. There was no internet at the time. And I would have had that patent, and I didn't get the patent because I foolishly abandoned it, and it's a multi-billion-dollar industry now. Another thing that happened is a professor at Stanford that I knew, I was talking to him, and one day he said, would you like to do some expert witness consulting? He was the expert witness testifying, and I would be the person behind the scenes who's doing the real work and telling him what I did, and we'd go over it. He was playing the role that I play now. And I said, well, I don't know. And then he told me what it paid, and I said, I'm in. It pays very well. And one of the first cases I worked on was a case, Texas Instruments against Samsung. And they hired a team of very highly educated people with a lot of expertise. I was fortunate enough to be on that team. And it was all over a patent, one patent that Texas Instruments held. And we would work long hours, and we'd say, and Texas Instruments would pay for our equipment and our rooms, our hotel rooms. We didn't see our families for weeks at a time. And we thought, wow, they're spending a lot of money on us. And then one day we got a phone call from the attorneys who said that the case had settled, and this was public information, it was in the newspapers, it settled for $1.1 billion with a B. So I realized that that one patent, that a Stanford Business School professor had said patents are not valuable, and here I saw one patent that was worth over $1 billion. And then the next year they hired me again in Samsung v. Hyundai, where Samsung sued Hyundai for patent infringement, the same patent, and they won another $1 billion. And at that point, I realized that the Stanford professor was wrong. Now, not every patent is worth that. Very, very few patents are worth that. But some patents are worth. They're all worth some amount of money, and it was worth pursuing.
So one of Stanford professor gave you wrong suggestions, and another actually corrected you and put on the right path.
It's not uncommon in a lot of areas, but what I've found is that with patents, if you find, for example, professors in law schools tend not to like patents very much because they like publishing their results and they want those results to go to everybody, and a patent is a way of restricting somebody's work. So if you go to the Stanford Law School, you'll find professors who generally will say that patents aren't very good because it restricts getting information out. But if you go to the engineering school, you're more likely to find professors who've created something valuable and who want to protect it because they can license it to companies.
Okay.
And if you talk to Stanford administrators, the people who in charge of the finances, they will tell you absolutely patents are very, very valuable because Stanford and a lot of universities make money from their professors' research by patenting it and then licensing the patents. Interesting that the business school professor who talks about business would say patents are not valuable, but the people who run the business of the university will say patents are extremely valuable.
Great. So you mentioned a couple of cases from your practice. Do you have any other cases you want to share?
Sure. So I have been involved in some very high-profile cases, some of which I cannot talk about, and some I can. The one that everyone often asks me about is Facebook v. ConnectU. I don't know if you saw the movie The Social Network.
Yes, I did.
So in that movie, much of it is about the fact that Mark Zuckerberg, who started Facebook, was working with some students, the Winklevoss twins at Harvard, and there were claims that he had used the code he developed for them or used their code because they started first to develop Facebook. And so that was actually my first major case using our tools, and that really tested the tools that I had developed. And I can tell you that when I first was called by the attorneys, I was told that they represented a company called the Facebook. And I remember talking to the attorneys, and they said they had a whole lot of work for me to do. They had heard about my tools, the compared software, and they needed to find out for sure if there was any copied code. And we talked about an agreement, and I hung up, and my wife said, what was that about? I worked out of my house at the time. And I said, well, it's some company called the Facebook. I've never heard of them. And I just hope they can pay their bills because they've got a lot of work to do for me to do. So needless to say, they paid their bills. It turned out to be really the case that got me started, at least in proving out the tools that I had developed. After that, I worked on a case, Symantec v. IRS, where Symantec was taking the IRS to court because the Internal Revenue Service claimed that Symantec owed up to $2 billion in back taxes. And it depended on how much code. It's a little bit different than the other cases I've worked on. This depended on how much code they had developed in Ireland versus how much code they had developed in the United States. that determined how much taxes they paid. It's something called transfer pricing, which I know very little about. But I had worked with the attorney on another case, and we were having lunch, and he said, well, this isn't a copying case, but we need to compare code to find out how much changed. He said, do you think you could do this? And I said, I think so. Well, we signed a contract. We improved our tools for this specific kind of analysis. And in the end, we saved Symantec $500 million in back taxes. And they were very happy. They threw a party for the attorneys and for me, and another great case for us.
I guess that software you have, plus services you and your team, now growing team, offering the companies, helping to check in great details all the algorithms and codes the company use in their software.
Right.
And how the people will find you on the internet or in public space?
Well, they can search for the company name, Software Analysis and Forensic Engineering. That's the software company. My consulting company is Zeidman Consulting. It's important to remember E before I.
Okay.
If they search for me, they'll see I've written a lot of papers. I'm an engineer, but I've written a lot about patents and intellectual property. I have a book on the subject, and they'll probably find that I've written a lot about patent reform. There's a lot of Congress is talking about patent reform, and I've written a lot about that in articles and blogs.
So let's come back to your book. What's the name of your book?
So the book is the Software IP Detective's Handbook, and it talks about the tools that I've developed, and it's really divided into 3 different sections. And in the beginning of the book, it tells you which section it recommends that you read. If you're a lawyer, you can read the part on software, and it describes in terms that a lawyer can understand. I won't say they're not technical, but they're not deeply technical, about how software works. If you're a software engineer, then you can read the section on intellectual property. It talks about the history of patents, copyrights, trade secrets, why we need to protect them, how we protect them, what things are protected, what are not. Hopefully people won't make the same kind of mistake that I made, that they'll read my book and say, oh, I really can and should protect my intellectual property, because it can be very valuable. And then the third section is mathematics, and I don't know if anybody reads it, but I hope that they do. I hope that mathematicians read it, but it shows the mathematics behind the algorithms that are used to compare software.
Now, you mentioned reforms in patents.
Yes.
So what we should pay attention to?
It's a very important topic, and I'm glad you brought that up, because a few years ago, I think it was about 2 or 3 years ago, the America Invents Act was passed by Congress, which changed the rules for patenting. And there was a lot of discussion at the time about how do we make patenting better for America, better for business. And in my opinion, and the opinions especially of a lot of entrepreneurs and individual inventors, the America Invents Act actually made things worse for the individual inventors. As one example, I don't want to go into detail, but in one example, it used to be that the first person to invent something had the rights to a patent. So if I'm sitting in my kitchen and I come up with a great idea and I figure out how to do it, the important thing is it can't just be an idea. It has to be a way of doing it. Whatever it is, a better toaster, and I can draw a diagram of it. I can submit that to the patent office, but I can submit it later. I don't have to rush to the patent office. I can find investors. I can ask, friends and relatives for money. I can spend time perfecting it, and then go to the patent office. And if General Electric comes later and patents it, I can go and I can go to court or go to the patent office and say, look, I can show that I invented it first, and so then I get the patent. The American Invents Act changed that so that the first person to get to the patent office gets the patent. Now, if you think about that, the people sitting at their kitchen tables who don't have money but have a great idea are not going to because to get to the patent office, you need to hire an attorney, draw up a very specific document, the patent application, and pay fees to the patent office.
Every year.
Right. Well, actually, it's every year until it issues, and then every few years after that. And it's a lot of money,
Right.
and a lot of individuals don't have that. Of course, a big company has teams of lawyers and engineers. They can write up patents and just put them out. So it really helped the big companies that can get to the patent office first. Now, unfortunately, that passed. What's happening now is there are some bills in Congress. One bill in the House of Representatives just was delayed, although now they're saying they're going to act on it very quickly. But they want to do further reforms. And people like me, the individuals, my company is still fairly small. I'm saying that, and even if it wasn't, I understand how the individual inventor thinks and what resources we have. I'm actually talking to members of Congress, and I hope other people will at least think about this, that we've already had one reform. It was only about 3 years ago. Let's wait to see what the consequences are before we start making more reforms. But Congress is so eager to say, well, we've got to have more and more reforms. And the pressure for these reforms are coming from the big companies. I have nothing against big companies. I think they're terrific. I've invested in companies that have been big and become big. But, when the big companies are saying we need this reform to help the individuals and help the small companies, we have to start thinking, is that really what's going on here?
Great. So now, for those who are still watching our video, what would you wish them?
What would I wish them?
Yes.
Well, I certainly wish them success. I hope that if you're inventors and entrepreneurs, take your best idea. I advise a number of startup companies, and I'd say take your best idea and file a patent on it. Talk to an attorney. Don't file it on your own. There are attorneys or patent agents or people like me who just like working with small companies to advise them how to get a patent. And it's like an insurance policy. If your business succeeds, then your patent is defensive. Somebody sues you for patent infringement, you have a patent that you can sue back. Or they try to license it, you can license it to them, and you reach a deal through negotiations. But if your company doesn't succeed because you run out of money, or the market isn't there quite yet, or the economy goes into another recession, things that are often beyond your control, having a patent is like insurance. It means that you still can profit, still get recognition for the great invention that you came up with.
Great. And of course, you are here in Silicon Valley.
Mm-hmm.
In Cupertino, so here local to Silicon Valley, and also you travel and offer your services all over the world. Is that correct?
That's true. We have, my consulting firm has jobs. We do work on litigation all over the world. I'm currently an expert witness on that case in Finland, South Africa, Australia, and in the past, I've been in the UK and Germany. It's pretty exciting, and you get to see a lot of different legal systems. You get to see a lot of inside companies in what they're inventing, what they're doing, and how they operate. So it's been pretty fun.
Not to mention that's why your team is growing and able to offer services to more and more companies all over the world, as it's important to do the honest work. And it's important to have your patents recognized and be sure that it's bringing good to the whole world.
Yeah, one thing that does make me feel good is that before we had these tools for litigation, there's still a lot of uncertainty in litigation. People can misunderstand things, juries can misunderstand, judges can misunderstand, but when it comes to the specific things that my tools address, like software copyright infringement, before my tools, mostly it was one expert's opinion against another. Which one seemed to be smarter? Which one seemed to have more experience? Sometimes, what did they look like? This one has a beard and glasses, and this one doesn't. And what I'm hoping is little by little we're changing that by making this a very specific process. That when you get to the end of this specific process, there can still be disagreement, but much less disagreement. And so I really think that we're helping make the outcomes more just.
Great. I mean, you're in this area for many years right now, and we wish you the best.
Thank you.
And we will follow up with Bob pretty soon, just so you update us on upcoming reforms in patent litigations. And a lot of startups like to see what's going on in their patenting world, and startup developments of software, of course, always important. And it's not only startups, big companies, corporations,
Yeah.
pretty much everywhere software right now.
That's one thing that's nice. People sometimes say, which companies do you work for? Is it software companies? And I say yes, and every company these days is a software company.
Well, great. We'll see and follow up with you again, and check his book. Goodbye, Olga Media and Bob Zeidman.
Okay, thank you.
Thank you.